The question is, what happens? There are some legal questions. First of all, if they pass a repeal, it's most likely going to be tied up in court, and we'll have the folks over in the Ohio Supreme Court deciding whether the legislature can repeal House Bill 194 or whether the referendum stays on the ballot. And depending on how long that question takes, it's very difficult for boards of election to plan. We can't start counting back from November 6th because it's too late by then. Early voting starts 35 days before the election. Military early voting starts 45 days before the election. Election officials have to have ballots ready 60 days before the election. We're not counting from November, we're counting from a much earlier time frame, and it takes planning. Anyone who has worked in a Secretary of State's office, a Board of Elections office, or even worked as a poll worker knows that you don't plan an election the night before. It takes time for them to put this in place. If they pass a repeal of 194, or if they pass any replacement legislation, it is going to take time for election officials to be able to put that in place. And as Sam pointed out, it takes on average 2 years or 24 months for both election officials, poll workers, voters to adapt to changes. The last time Ohio had major election law changes was in 2006 when they passed House Bill 3 and House Bill 234. And when they passed House Bill 3, part of that included voter education, so that boards of elections and the Secretary of State would help voters learn about changes and adapt to them. All of the proposals that have been put forward in the last 12 months do not include that. So not only would any changes be difficult for election officials to plan for and put in place, we're basically inviting confusion and trouble for this fall's election, and that's what we want to avoid.
We would question what's the message that the General Assembly is sending to the community if they repeal 194. What is the message that they're sending? One, it was a bad piece of legislation, we're going to rescind it. But the historical precedent and the legal battle that will ensue after that, this has never happened where people have gone out and said on a referendum, we want to speak. And then simultaneously in the process, the General Assembly repeals it. That's never happened. So the question is, what's the message they would be sending to us about the legislative process and our efforts to engage in that legislative process? We don't believe the courts would support the idea that people will, their voice through their efforts are being taken away from them. We don't believe the courts are going to support that because that creates a precedent that says there can be a merry-go-round of legislation anytime the General Assembly wants to play a game. And they can pass legislation, we can go out and do what we need to do, and then they repeal it. We don't think the courts are going to support that.
Sam, could the argument be made, though, that people did get their voice heard? They got the petitions, they got it on the ballot, they got the referendum in front of the voters, and that in itself caused the legislature to react and repeal the bill. Couldn't they argue that, well, your voice was heard, the lawmakers just reacted before you had the chance to do the full vote?
I hear what you're saying, but what's the message to us as a community with regards to that? Our efforts were put in to create an opportunity for our voice to speak on this particular piece of legislation. They're going to deny us that opportunity, and they're creating a precedent that could take us into a place we really don't want to go. Does that mean simultaneously we have to get the petitions and we have to go into court to protect our rights to have our voice in order to do this? It makes it much more difficult. Does that say that the General Assembly, do they really want the participation of people? Do they really want people to have their voice? It's a sham to say to me, I heard you and I'm now going to repeal it after you put all this money and effort into it. You should have heard us at the hearings. You should have understood based on the letters. You should have understood based on the phone calls. You should have understood based on the visit that people gave you. You should have understood a heck of a lot earlier than to allow us to go through this whole process of creating our own voice. And now you're going to deny us that. That is unprecedented. That is dangerous. That is a symbol that I don't want to see our government send to its people.
It's also a message that is in direct contradiction with the state constitution. The Ohio Constitution makes very clear that the power of referendum belongs to the people. and the legislature cannot take that away. While the Ohio Supreme Court has never addressed a case directly like this, they have said in other recent cases that the legislature cannot sidestep the power of referendum. The most recent example was when there were policy changes that were inserted into a budget bill. And budget bills are the ones that are exempt from referendum. All other policy changes made through legislation are subject to referendum. The legislature and the governor tried to push policy changes through the budget to make them referendum-proof, and the Ohio Supreme Court said no. Those policy changes are still subject to referendum because the power of referendum is reserved to the people, and the other two branches of government are not allowed to sidestep it. So while the courts have not addressed this exact scenario, all of the recent case law has indicated that this power belongs to the people, not to the legislature, and we're asking them to respect that.
Couldn't the argument be made, though, that by repeal, the bill's gone, you don't have to spend a lot of money to try and educate voters on why it's a bad bill, there's no chance the voters then might actually uphold the bill and keep it in place, it's gone. Why not just let them repeal it and then focus in on anything that they might try and replace it with?
Well, as Sam mentioned earlier, what we've seen with a lot of this legislation is it's never one issue. They're opening Pandora's box anytime they legislate on election law with what other amendments are going to be piled onto that, what other changes are going to be included. So that's one concern. The other concern is that it's taking this voice away from the people and taking away the people's veto of whether they want this or not. And if the legislature repeals 194 before the people get to vote on it, what's to stop them from reenacting this 2 weeks later?
Have you guys said, I mean, would you be filing the lawsuit if they went ahead and repealed this, or would it be Fair Elections Ohio that would bring the lawsuit? Has that been determined?
I know a number of groups have been discussing that issue. I don't know that it's been determined at this time.
You can be assured that if they establish this precedent, there'll be a reaction, and then probably it would be a legal reaction. Because I want you to be clear what they will be doing. As the Constitution says, you can't deny the people a referendum. They would be denying it. I know some people will say, well, the substance of the act is that the law is no longer in effect. That's not important. It's the symbolism of our ability to respond, and they denying us that opportunity to respond, where it's buried in the Constitution, it's buried in the history of the state, and people should always have regress of their grievances. That should be a process, and the Constitution gives us that. And the symbolism of them denying that to us is beyond belief.
So it's undetermined yet who would bring that lawsuit, but
right.
one
You would be assured that some groups would come together, coalesce, and something would happen legally, yes.